H425, an act to keep college graduates working. As you may know, I am a former 7th grade public school teacher, and I have been an education attorney for more than a decade, including significant legal and policy work in higher education and as chief legal counsel at the Massachusetts Executive Office of Education. More often than not, Massachusetts is a leader in forward-thinking education policy. When I review national analyses and publications, I'm often pleased to see Massachusetts identified as a pioneer in a promising practice or out in front on an education issue. So I was quite surprised last year to read about Florida's repeal of its license suspension for default law and see Massachusetts listed as one of the only states that still authorizes the denial of a professional license to a student loan defaulter. Under our general laws, Massachusetts mandates that boards of registration deny a professional or occupational certificate or license to any applicant who is in default on the payment of certain educational loans. H425, which I filed, would repeal these statutory provisions. Last year, as I mentioned, the Florida legislature repealed a similar law in a bipartisan vote, joining other states including Alaska, Arkansas, Hawaii, Illinois, Iowa, Kentucky, Louisiana, Texas, and Washington that have repealed these so-called license suspension for default laws in recent years. More than half of all American students, including yours truly, go into debt while pursuing post-secondary education. With record high unemployment due to the COVID-19 pandemic, many residents in the Commonwealth undoubtedly have struggled to meet their financial obligations, including with respect to student loans. As they and their families strive to recover from the financial fallout of the pandemic, the last thing we should do is deny them access to their professional pursuits because of student loan defaults. And as I shared in my written testimony, even beyond the pandemic recovery, repealing our license suspension for default law is the right, sensible policy. At any time, denying an individual access to the profession for which he or she is trained solely because of a loan default has the perverse result of making it more difficult for that individual person to make payments and further hindering their ability to earn a living. I understand from some research that our state boards of registration may not always enforce these requirements. That should not deter the legislature from eliminating these draconian statutory provisions in order to keep our college graduates working. Please act favorably on H425. Thank you so much.
Thank you, Rep. Lipper-Garabedian. Does anyone on the committee have questions for the Rep?
Madam Chair.
Please.
Thank you so much, Madam Chair, Mr. Chairman. And I just want to really thank the representative for bringing this forward. It's this kind of thing that we do that we just continue to punish poor people. And why aren't, to be able to give people access to be able to work their way out of debt is much better than just trying to punish. And I think that this just goes along with the fees and fines that we just keep dumping on people. And so I really appreciate, I didn't know about this, that this is another thing that we do. And so I really appreciate Representative Lipper-Garabedian's attention on this and taking action, and I certainly would support this work. Thank you so much, Madam Chair.
Thank you, Rep. Farley-Bouvier, and I also want to note that we have been joined by Rep. Sina.